certainly seems to me that if they were arrested and charged for inciting disorderly conduct, if that's really what happened, if that really was what the facts were, then I think the district court would have been right in enjoining that. So I suspect we'll probably see that ordinance before the courts again. Well, moving from the shores of Lake Michigan to the shores of Lake Mendota, and that brings us to our second code word, Mendota, M-E-N-D-O-T-A. And the University of Wisconsin, case of Badger Catholic versus Walsh. Well, the University of Wisconsin, like most schools, collects student fees from the students for a wide variety of things to enhance the educational experience. One of the things that that goes for is money going to various student organizations to bring in speakers and to do various programs and you know, to put on different programs for the students. And in the past, they provided these funds for a wide variety of organizations. Sustainable agriculture, certainly important in an important agricultural state. Social justice, healthy sexuality, a wide variety of things. In fact, the rules were set up such that these funds could be used for pretty much any kind of speech except prayer, proselytizing, or religious instruction. Well, I don't know if they used this word, but it was pretty much beyond dispute. Badger Catholic, as the name implies, a student organization, a student religious organization made up of Catholic students. They applied for some funds, and again, I don't know if they used these words in their application, but it was pretty much undisputed that they were going to use the money for prayer, proselytizing, and religious instruction. And the student government said, nope, those are all the things in the world that you can use this money for, those are the only three that you can't use it for. So your request is denied. Well, they took this to court and said, well, wait a minute, these other organizations are getting money, the sustainable agriculture people are getting money, the healthy sexuality people are getting money. Why can't we get money for our religious programs? And the university kind of made the argument that they are going out of their way, kind of like using an overabundance of caution not to violate the Establishment Clause. That was kind of what their argument was. And no, the courts, both the lower court and the Court of Appeals, said no. An overabundance of caution to make sure that you don't violate the Establishment Clause is not a defense, and you have to provide this to all organizations on equal grounds. The university made the argument that the court didn't buy, was that they felt they could discriminate based upon viewpoint, or no, they felt that they could discriminate based upon content as opposed to discrimination based upon viewpoint. So they, would have argued that, well, yes, we gave money to the sustainable agricultural people. If a non-sustainable agriculture group had come in and wanted money, yes, we would have given that money to them too, because we don't discriminate based upon viewpoint, either pro-sustainable agriculture or anti-sustainable agriculture. But the content can't be religious. And the court said, no, you can't discriminate based upon content when you're using funds like that. They granted a declaratory judgment that the university is required to fund this particular cause. Well, moving from the First Amendment to the Second Amendment. Now, if you're like me, a lot of you, when you were in law school, the Second Amendment was kind of a footnote in your constitutional law textbook. There really was not much jurisprudence on that. Because, and I think this is safe to say that, 20 years ago or even 10 years ago, advocacy groups like the NRA and other groups like that, I think concentrated most of their efforts in the political arena, in state legislatures and Congress, and had not really litigated very many issues. Well, that seems to be changing a lot, and the Second Amendment is getting litigated a lot more. Sometimes organizations like that, you want a compelling plaintiff, you want a sympathetic litigant in your case. They didn't get one in this case, unfortunately, but I think it's a kind of an important Second Amendment case. Here the defendant, frankly, was a pothead. He was this 18-year-old gentleman. He was arrested on some outstanding warrant. The court didn't say what the warrant was for, so probably something stupid, but he got arrested on this warrant. And when he was arrested, he had various things in his pocket. One of those items was a loaded pistol, and the other item was 0.7 grams of marijuana. Now, I don't know how much that is. I'm guessing 0.7 grams is a pretty small amount, so it was probably just a little bit for his daily enjoyment. He confessed, as the court said. One of those cases, he made his own. If he would have just shut up, he probably would have been fine. But when he was arrested, he said various things to the police that they took as a confession, and according to the court, he confessed that he had been smoking marijuana daily since age 16. The court also pointed out that he had been twice arrested for possession of marijuana. Now, they didn't say anything about convicted. They didn't say anything about whether this outstanding warrant had anything to do with that. He had been arrested twice for possession of marijuana, but no indication in the case that he was ever convicted of any drug charges or anything. Well, again, he's not the most sympathetic litigant in the world, and I suspect probably the world is a little bit better placed that he's in the custody of the Bureau of Prisons for a couple of years. But he was charged and he was convicted of violating a federal statute, which makes it a felony for someone who is, quote, an unlawful user of or addicted to any controlled substance to possess a gun. So the elements of that offense are you are addicted to or habitual user, unlawful user of an illegal drug, and you're in possession of a gun. And that's it. It's not that you were previously adjudicated to be a drug addict or that you were previously convicted of a drug offense or something like that. What the charge is that you are an unlawful user of or addicted to any controlled substance. And he, the first thing the guy blurted out to the cops was, "Oh yeah, I smoke that every day." Well, and the gun was in his possession, so he was convicted of this. Well, undoubtedly he didn't have much else to go on, so he put all of his eggs in the Second Amendment basket, and he appealed there. I'm sure. I bet the NRA wishes that they could have found a little bit more compelling person to bring this particular case. Good work by a federal public defender here, undoubtedly, bringing this case forward. The argument was that this violates the Second Amendment. It says right of the people to keep and bear arms. It doesn't say the right of the people who are not potheads to keep and bear arms. It says the people. So this violates the Second Amendment. He was just keeping and bearing arms. Well, the court took a hard look at that. They did affirm the conviction, like I say, this is a pretty new area of the law, so it's pretty much up in the air. Even simple things like what is the standard of review? How do we judge the statute? Is it rational basis? Is it strict scrutiny? Well, the court didn't answer that question, and it pointed out that the Supreme Court has yet to answer that question of what exactly, in general, the standard of review is for looking at statutes like this. But they had to define it, obviously, for this particular case. And the standard that they came up with I don't know if these words really mean anything, but this is the standard that they used. It has to be more than merely rational. So it's not just, did Congress have a rational basis for keeping guns away from users of drugs? So it has to be a little bit higher than that. They didn't go out and say what it really is, but they said it has to withstand some form of strong showing. They didn't say exactly what that form of strong showing is. But they said that they are not waiting, and nor did the Supreme Court want to wade into the levels of scrutiny quagmire. Well, that quagmire is out there, and that's going to be waded into by courts in upcoming cases, I'm sure. So it'll be an interesting few years in some of these cases to see what standard review does come out of this. But in this case, it has to be some form of strong showing, the court said. And a little bit more particularity, whether the government has made a strong showing that the challenge statute is substantially related to an important government objective. So some of those words are words that have been used before in other constitutional law contexts. So I guess there is a little bit of a standard starting to evolve. And that's what the standard is it substantially related to an important government objective. But the court said that perhaps, and it'll have to wait for a later case, the question of whether a different kind of firearm regulation might require a different approach. So this is still very much open. And here, the court said that this regulation was valid. Again, not too hard to do here. The litigant there is not a very compelling person. He was not some hunter out lawfully hunting, or he was not somebody with any kind of need for security in his home. He was just some punk out walking around with a loaded gun and some marijuana. So probably not the kind of person that the NRA would hold up as their quintessential law-abiding citizen. And here they held that the regulation was valid. And they said that the purpose of this kind of statute is to keep guns out of the hands